You may be watching this video today with some common questions about the OSHA inspection process, such as what are the reasons OSHA conducts a safety and health inspection at certain workplaces, what the differences are between an OSHA complaint and an OSHA inspection, what actually happens during the inspection process, and what happens after the inspector has left and what to do next. Our goal for this video is to answer those questions and provide a general overview of this topic. At Lancaster Safety Consulting Incorporated, we help our clients with all aspects of their safety and health program, including OSHA inspections. We've also been designated by OSHA as an OSHA Star VPP mobile workforce, and as part of this program, our team has worked alongside OSHA officers while conducting inspections. We also have several former OSHA officers on our team. While the information we provide today will be informative, it should not be considered legal advice. Each OSHA inspection will be different depending on your industry, site hazards, and the severity of violations found. We'd be more than happy to discuss workplace-specific questions if you'd like to give us a call at 888-403-6026. Now, let's dive in. OSHA cannot inspect all 7 million workplaces it covers each year, so the agency seeks to focus its inspection resources on the most hazardous workplaces in the following order of priority. Imminent danger situations. These inspections include hazards that could cause death or serious physical harm and receive top priority. Severe injuries and illnesses. These inspections occur directly after a fatality, reportable injury, or illness. Worker complaints. We will talk more about these types of inspections in detail a bit later. Referrals. These inspections occur when referrals of hazards stem from another federal, state, or local agency. Individuals, organizations, or other media receive consideration for an inspection. Targeted inspections. OSHA will analyze data in certain NAICS codes to conduct targeted inspections. These inspections are aimed at specific high-hazard industries or individual workplaces that have experienced high rates of injuries and illnesses. And follow-up inspections. During this type of inspection, OSHA will check for abatement of violations cited during a previous inspection. OSHA carefully prioritizes all complaints it receives based on their severity. For high-priority hazards, OSHA will most likely conduct an inspection. For lower priority hazards, with permission of a complaint, OSHA may telephone the employer to describe safety and health concerns, following up with a document providing details on the alleged safety and health violations and hazards. Keep in mind, OSHA will not provide the employer the name of the employee who sent in the complaint or the referral. So an OSHA officer is at your door. Now what? Well, before conducting an inspection, OSHA compliance officers research the inspection history of a worksite using various data sources, review the operations and processes in use, and the standards most likely to apply. They gather appropriate personal protective equipment and testing instruments to measure potential hazards. Your company should designate a company representative to accompany the compliance officer during the opening conference and the walk-around process. The representative should be an employee at the company who is well-versed in the operations at the facility, recognizes safety and health hazards, and can have access to all documents OSHA may request for during the inspection. For example, during the opening conference, the compliance officer may request specific documentation related to the inspection and expect for it to be immediately available to be reviewed. Contact Lancaster Safety Consulting Incorporated if you desire for us to provide an overview of your occupational safety and health program. The designated representative shall present all documentation that OSHA requests to review, and only that information. Providing more information than requested may seem like a good idea at the time, but can also uncover other issues in OSHA's eyes. Here are a few common items the compliance officer may request depending on the type of inspection. For example, if the inspection is in result of a severe injury on the job site, the compliance officer will most likely ask for a copy of your accident investigation form. Please keep in mind that the documents requested will vary on the type of inspection and industry. You should also present safety committee paperwork and any other written materials that demonstrate your company's good faith efforts to comply with the applicable OSHA standards. An authorized representative of the employees, if any, also has the right to go along. In any case, the compliance officer will consult privately with a reasonable number of employees during the inspection. Following the opening conference, the compliance officer and the representatives will walk through the portions of the workplace covered by the inspection, inspecting for hazards that could lead to employee injury or illness. During the walk-around, compliance officers may point out some apparent violations that can be corrected immediately. While the law requires that these hazards must still be cited, prompt correction is a sign of good faith on the part of the employer. Always give LSCI a call upon conclusion of an inspection. OSHA has up to 6 months to issue citations. If you happen to receive citations, we will work with you to provide abatement assistance by providing appropriate abatement methods for the citations and support you with the informal conference with OSHA. Employee interviews may be conducted at any time during the walkthrough or any follow-up visits. Management is not permitted to sit in on these interviews. No citations are issued on the same day for an OSHA inspection. For each apparent violation found during the inspection, the compliance officer has discussed or will discuss the following with you: the nature of the violation, possible abatement measures you may take to correct the condition, possible abatement dates you may be required to meet, and any penalties that the area director may issue. You can call Lancaster Safety to help walk you through the next steps of the process. All OSHA notification citation packets are sent by certified mail. If you agree to the citation and notification of penalty, you must correct the condition by the date set in the citation and pay the penalty if one is proposed. If you do not agree, you have 15 working days from the date you receive the citation to contest in writing. However, before deciding to contest the citation, you may request an informal conference with an OSHA area director within the 15 working day period to discuss any issues related to the citation and notification of penalty. Work with your LSCI representative to set up a date and time for the informal conference at the local OSHA area office within the 15 working day period. Post the Notice to Employees of Informal Conference found in your citation packet near the citations with the accurate date and time. Discuss with your LSCI representative your main concerns for the citations, whether it is the classification, the standards cited, abatement deadlines, overall penalty, or all of the above. Abatement is the correction of the safety or health hazard violation that led to the OSHA citation. Review the methods of abatement and prepare a plan with your LSCI representative on how to correct proposed violations. Violations are categorized as willful, repeat, serious, other than serious, failure to abate, and de minimis. Willful violations exist under the OSHA Act where an employer has demonstrated either an intentional disregard for the requirements of the OSHA Act or a plain indifference to employee safety and health. Repeat violations. An employer may be cited for a repeated violation if that employer has been cited previously within the last 5 years for the same or a substantially similar condition or hazard, and that citation has become a final order of the Occupational Safety and Health Review Commission, OSHRC. Serious. A serious violation shall be deemed to exist in a place of employment if there is a substantial probability that death or serious physical harm could result from a condition which exists, or from one or more practices, means, methods, operations, or processes which have been adopted for or are in use in such place of employment, unless the employer did not and could not, with the exercise of reasonable diligence, know of the presence of the violation. Other than serious. This type of violation is cited in situations where the accident or incident or illnesses that would be most likely to result from the hazardous condition would probably not cause death or serious physical harm, but would have a direct and immediate relationship to the safety and health of employees. OSHA may impose a penalty for each violation. Failure to abate. A failure to abate violation exists when a previously cited hazardous condition, practice, or non-complying piece of equipment has not been brought into compliance since the prior inspection. For example, the violation remains continuously uncorrected and is discovered at a later inspection. If, however, the violation was corrected but later reoccurs, the subsequent occurrence is a repeated violation. OSHA may impose a penalty for each violation. Each January, OSHA increases their penalty amounts to adjust for inflation. The Inflation Adjustment Act went into effect on August 1st, 2016, so it has been in place for a while now, but this was a significant change by the administration because fines increased approximately 80% the first year this took place. Fines have increased steadily each year since. Listed here are the OSHA penalty amounts for 2021. Please note that states that operate their own occupational safety and health plans are required to adopt maximum penalty levels that are at least as effective as federal OSHAs and may differ from the information you see here. After the classification as serious or other than serious and the gravity-based penalty have been determined for each violation, the penalty reduction factors for size, good faith, and history shall be applied subject to the following limitations. Penalties proposed for violations classified as repeated shall be reduced only for size. Penalties proposed for violations classified as willful shall be reduced only for size and history. And penalties proposed for serious violations classified as high severity or greater probability shall be reduced only for size and history. Thank you for taking the time to listen in today. If your company is looking for assistance on a recent OSHA inspection, give Lancaster Safety a call today at 888-403-6026. We can also help with safety and health training, on-site or online, written programs, audits, record keeping, and other OSHA compliance help. Visit our website at lancastersafety.com to learn more. Thank you and have a safe day.